Themselves here, go ahead, Lee.
I am Lee Powers. I am the Chief Operating Officer. I am super excited to see new faces here today. So that's exciting. And then I'll introduce Ben. He is from Makower, Abbate, Guerra, Wegner, Vollmer.
Got them all.
I can say that.
And
kick it over to you, Ben. Go ahead.
Yeah, sure. Hi. So good afternoon. Thanks for having me, KS, and all the board members here and online. It's a pleasure to see so many people. Again, I am with the law firm of Makower, Abbate, Guerra, Wegner, Vollmer, Crosby, Still, Nash, Young. That's right. We do specialize in condominium and homeowner association law. So we represent about 2,500 different associations throughout the state of Michigan. This is our bread and butter. This is what we do day in, day out. So we do consider ourselves to be the experts. I think we've got about 11 attorneys at this point. We've got a pretty large support staff. You know, personally, I've practiced law. This is my 18th year of law. It's my 10th year at the Makower Law Firm. So I like to think I know a little bit about what we're going to discuss today and association law in general. Lee, do I get started? Do we have other introductions?
Nope,
what do you like?
You are good.
So today we are going to talk about everyone's favorite subjects: violations and enforcements, consistency, authority, and compliance. So if you're a board member, you are aware of having to deal with bylaw and restriction enforcement. So, and I've got to remember to, here's our lovely presenters. Just as a disclaimer, even though I am an attorney, this presentation provides general information and not legal advice and should not be used or taken as legal advice for specific situations. You should consult legal counsel before any action or making any decisions concerning the matters in this presentation. This communication does not create an attorney-client relationship between Makower, Abbate, Guerra, Wegner, Vollmer, PLLC, and the recipient. I'm going to give a lot of general information, but a lot of your documents in almost every situation is going to be a little bit unique, and it's going to have something that may kind of vary from the norm. So again, you really want to consult with management, consult with your attorneys for any unique types of bylaw violations, enforcement actions. You run that for me? Appreciate it. Why enforce the governing documents? Why should we do this in the first place, right? You have a fiduciary duty, obligation to do so. You're the board of directors, and you have a higher obligation to the rest of your co-owners. You have to act in the best interest of the association. Everybody else can worry about and think about only their own best interest. You have to think about the best interest of the entire community. And everybody who moves into your community voluntarily subjects themselves to your restrictions, bylaws, restriction, whatever it is. And so, and the point of those restrictions is to help maintain property values and help maintain your community in the condition that enticed people to purchase there in the first place, right? I know a lot of times people may look at these as a burden. It's my property, I get to do what I want, and these different types of arguments. But again, people have volunteered to move into this community because it's in the condition that it's in, arguably a lot of times because of the restrictions that are there. So you as board members have an obligation to enforce the governing documents. Allowing violations will promote similar violations in the future and can frustrate future enforcement action. You know, letting one slide for whatever reason, the next time that violation comes up, I promise you, that violator number 2 is going to point to violator number 1 and say, but you're letting him get away with it. Even if you don't know about this other violation, one of the first defenses that we get to many bylaw violation letters, whatever the case may be, is, well, my neighbor's doing the same thing. And my response to that is typically, great, thank you for letting us know. Please provide us with their name or their address, whatever. We'll look into it. And we'll pursue our own, we'll pursue whatever enforcement action is required, but that's not a defense to your own violation. We still need to address your violation. So if you're on the board, you've probably heard this, but so-and-so is doing it as well. Failure to enforce the documents may be a reason people decide to run against the current directors in the next election. So at least with regard to kind of your own self-interest in, I want to serve on the board and make sure that these restrictions are enforced and that the community that I'm a part of is managed and operated in a particular way. If you're not enforcing the documents, that people will run against you on that all day long. And you've heard it. You've been accused of it. The board's not enforcing the documents, right? So just be aware. Those are some of the reasons why you should enforce the documents. And furthermore, directors and associations can be sued for failing to enforce the documents. Certainly with regard to the Michigan Condominium Act, there's legal obligation to enforce those restrictions. So MCL 559.207, this is going to be anytime you see a 559 there, that's part of the Condominium Act. Condominium Acts in Michigan are controlled by statute. Subdivisions are not. And so that's not a distinction we'll get into too much towards the end a little bit. But for condominium associations, we're often looking to the act. And again, section 107, I know it doesn't seem like it, but it says 207 right there. It's not always the best drafted document anyhow. If you look at it, it's section 107. A co-owner may maintain an action against the association of co-owners and its officers and directors to compel these persons to enforce the terms and provisions of the condominium documents. In such a proceeding, the association of co-owners or the co-owners, if successful, shall recover the cost of the proceeding and reasonable attorney's fees as determined by the court to the extent that the condominium documents expressly so provide. Typically, we're going to see documents that say in no event are co-owners entitled to an award of attorney's fees. But if you don't have that type of language in there and someone were to sue the association to enforce the documents, you may be paying for their attorney's fees in addition to the attorney's fees that you're paying for to defend yourselves against that legal action. So let's talk about your toolkit for correcting violations of the governing documents. So we're going to look at a number of different sections here. We're going to look at monetary fines, self-help and abatement, lawsuits, and evicting tenants. These are kind of the four main things that we look at. Why would an association often delegate violation administration to management, right? Well, we're the board. We're the ones who are there. We're the one getting the complaint. These are our neighbors. Why would we have management do this, take enforcement action? Maybe at a surface beginning level, it certainly makes sense to talk to your neighbors, right? But a lot of times, again, you as board members may realize that it's not just a simple talk to my neighbor. Oh, I realize I'm in the wrong. I'll start to do the right thing. A lot of times the bylaw violators that you're running into are belligerent. They believe that they're right. They believe that you cannot tell them what to do, right? And so having your management assist with bylaw violation provides a couple of different things. Consistency. Centralized administration helps ensure uniform application of the governing documents. Boards oftentimes and likely turn over more frequently than management, right? So management is going to have, hopefully, a good management company like KS is going to have a record of this is how we've addressed this in the past, right? Or we've had this same problem with this co-owner every year for the last 5 years, right? So you have that record, you have this consistency of record keeping and enforcement. Perceived fairness, this is again, and this is what I tell my clients as well, right? Let me be the bad guy. Let the management be the bad guy. Hey, you know what? We understand it. We received a complaint. We passed it on to management. The board has an obligation to fulfill these things. I know I'm your neighbor, but we're going to let management, that they're handling that, and you're going to have to comply with the actions that they're asking you to take. And then risk management helps reduce claims of select enforcement, bias, retaliation, and arbitrary decision making. Again, a common, it's not really a defense, but a common excuse that we hear with regard to enforcement of bylaw violations is the board hates me. The board is out to get me. The board is taking enforcement action because of who I am, not because of what I am doing, right? Because again, you're the ones who live in the community and may have more regular interaction with your co-owners, with your neighbors. Having management who's not there interacting with them every day, not their neighbor, is not seeing them when they're out walking the dog, helps us provide a uniformity. And again, a matter of, this is not a matter of personalities. This is a matter of enforcement. This is a matter of operations.
And we always preach as management, you guys are volunteers. You live in the community. You shouldn't be having this as a full-time job. You should let us do that. That's what you pay us for. And we love being the bad guy.
And that's a valid point. Again, I know some board members may thrive on the day-to-day and do that, but a lot of other board members, again, it's a volunteer position. I'm trying to do my best. This is not a full-time job for me. You are paying KS management. You're paying me to do it. Let us be the ones who are assisting you with this. Monetary fines. So this is one of our first enforcement mechanisms. Boards love monetary fines. They think they're great. I've seen mixed success with monetary fines. One of the first things we need to do is we need to check your bylaws for fine language and amounts. In order to be able to assess fines, your documents, whether it's your bylaws in a condominium or your declaration and your bylaws in a subdivision for a homeowners association, they need to specifically authorize the assessment of fines. So before we get into assessing fines, we want to look and see, do you have the ability to assess fines? And what are the options? You know, what are the fining options? For a lot of older documents, this is what I see. And this is what KS sees. $0, $25, $50, $100, right? And depending upon the community that you live in, that may not be very much of a deterrent. There may be someone in your community who's willing to pay, once you get to the $100 fine level, $100 a month, $100 a week, whatever it is, to leave their trash at the curb and not take it in, whatever the violation is, right? I mean, a fine's only a penalty if you can't afford to pay. So, but we need to look at that. And again, a lot of times boards who have been going through the fine process are, but we're at $100. Can we increase the fine? No, not if your documents don't allow it. You need specific language in there, which when we redo documents, we draft language in allowing the board to adopt higher levels of fines or fines for specific violations. But if that's not in there, you're stuck with the fine amounts that you have, unless your community agrees to amend your master deed and bylaws, which has its own cost. Adopt rules to provide additional detail regarding fines. Some documents will specify that the board has to adopt a fining policy before it can assess fines. It doesn't have specific fine limits and levels specifically in the bylaws. Now we have the opportunity for the board to adopt via rule what the fine levels are going to be, if there's going to be more severe fines for more severe violations. You know, so the Condominium Act permits the boards to adopt fines by rule. Again, we're going to look at an MCL section here, 559. A default by a co-owner shall entitle the association of co-owners to the following relief. Such other reasonable remedies the condominium documents may provide, including but without limitation, the levying of fines against co-owners after notice and a hearing. We're going to talk about that thereon, and the imposition of late charges for non-payment of assessments as provided in the bylaws or rules and regulations of the condominium. So if you look at your condominium documents and you don't see any specific fining language, or you see this language of fines is adopted by the board, now we can engage in the board adopting the fining policies and procedures. We have some pretty standard policies. We can assist with that. Of course, board policies and procedures, because they're not ensconced in the bylaws, can be changed by a different board, right? So they're not as permanent as having it in your bylaws there.
And it's important with fines to remember, as Ben mentioned, if they're not a fine schedule that actually forces enforcement, then it's useless. I've seen a community where there was someone that kept getting fined over and over for having a boat stored in their driveway, and they kept paying those fines, and they said it's cheaper than paying for storage somewhere. So it's your fines have to actually make it enforceable.
It's only a penalty if you can't afford it, right? Certain people can afford more justice than others. That's unfortunately the American way. Give notice. I mentioned that in the section that we just read. The association must provide notice that states with specificity the conduct giving rise to the violation and the rule or restriction that has been violated. This is not notice that a fine has been levied. Your first letter to the co-owner is not, you have a boat in your driveway. It is a violation of Article 6, Section 13. You have been assessed a $50 fine. That is not the notice. The first notice is, I would like to see, but again, it kind of depends upon repeat violators, but I'm talking an absolute first notice, a courtesy notice. I don't know if KS does these types of things, right? Because again, they're your neighbors. You have to live with these people. You want to give them the opportunity to realize that they're in violation and cure it on their own without escalating too much. After that, we have to give notice. We want specificity, And part of the notice that we're giving, is that my next slide, has to do with holding a hearing. So that section of the Condominium Act that we talked about says holding a hearing, notice and a hearing. The notice is going to specify the violation, and it's going to specify when a hearing is going to be held by the board of directors. Hold a hearing to determine whether a violation has occurred and what fine, if any, will be levied. Rather than presupposing guilt, only allowing an owner the right to appeal a violation, the association must provide a hearing before the board prior to the levying of any fine. Again, this is a penalty. This is different than a late fee, right? A late fee is arguably an additional cost that the association has actually incurred because someone has not paid their assessment. A fine is a penalty. The point of a fine, the point of a penalty is to change the behavior. And so when we, the association, are levying a fine, imposing this penalty, trying to change the behavior, we're acting as the judge. We're acting as the jury. We're the ones doling out justice in this case, right? And so there's a due process issue. We have to get the accused owner the opportunity to appear before the board, right? The judge and the jury in this case, and explain the situation. This is why my boat was there. My boat was there because my storage unit burned down that weekend and I had to put it somewhere. And I'm asking you for some leeway this time. I will have it moved within 7 days, whatever the case may be, right? Everyone's going to be a little bit different. But you have to have that hearing and the board has to make a decision. And then we're going to notify the co-owner what the board's decision was. Now, my communities that are doing this, and I have some communities that are very fine, happy, and they have a lot of hearings, and I have some that just don't that much. A lot of times the co-owner is not going to show up. Ben, they didn't show up. Ben, you told us to have hearings. Nobody ever shows up. Why are we taking our time to have these hearings? You have to do it. It's required by the statute. But their failure to appear is a default. We're just going to assume that you didn't appear, you didn't defend yourselves. We're going to find that the violation, we've got a letter, we've got a complaint, you didn't appear to defend yourselves, we're going to levy the fine and we're going to issue that.
And is the hearing something that could be held in the context of a board meeting, or do you have to have a separate meeting?
Yeah, have it during your board meetings. I have a community that issues a lot of fines. I don't think they're a KS property. But they have separate fining meetings. They were complaining to me because I've explained to them, you have to hold the hearing. You have to do these things. And they're having them twice a month. And Ben, we're at twice a month. I said, what? Do it once a month. Do it at your board meeting. Because again, your notice is going to say when the hearing is going to be. Your fine provisions, they probably have language in there that says you have to give them a certain amount of notice. Usually it's 10 days minimum notice, right? But Ben, we don't know what our next board meeting is going to be. We're comfortable with there will be a hearing at the next board meeting. Please contact management to figure out when the next board meeting is, right? So you're still giving them the notice. You're still giving them the opportunity. To that question, sir, remote hearings are an option. Again, this is just, if you get a speeding ticket, you can pay it. But you also have the opportunity to appear in court and explain yourself. Try to work a deal, try to get out of it, try to get some leniency in the court. That's what you're doing with regard to fines. Here's
a key point to that, though, that he said, is there's a window of time they have to give them between the notice and the hearing. It can't be your hearing tomorrow.
Yeah, that's right. I mean, it's usually a minimum, no less than 7 days before the hearing, no less than 10 days, right? Hey, don't pump a bunch of fine notices out. We got a meeting on Tuesday. That way nobody shows up. So don't play those games. Give everyone time to notice. It gets frustrating, I understand, but a lot of these things are hopefully going to be one-offs, and it's going to help to cure the situation. Adhere strictly to fine schedules unless bylaws or rules allow for different amounts at the board's discretion. We talked about this a little bit, but this is this guy's third fine. Can we? It's just not fixing the problem. I know our third fine level is $75. Can we make it $300? No. Again, unless your bylaws allow for you to adopt rules to change fines, and then even if you can adopt fining by rule, your bylaws are probably going to state that you have to give all of the co-owners notice of the rule. A lot of times it's 30 days before it takes effect. So you can't really spring a surprise $300 fine on a repeat co-owner, right? There's a mechanism for doing this. no one should be surprised, right? Or be able to claim surprise. I had no idea. What do you mean you had no idea? We sent you a courtesy letter. We sent you a notice. We've repeatedly, we've done all these things. We sent out notice to the entire community about what the board's fining policy is. We sent out notice to the entire community that the fine for this has been increased to $300. What do you mean you're surprised? If you're surprised, you're not paying attention. Fines can be collected like unpaid assessments and secured by the recorded lien. So again, Ben, we're issuing fines. He's not paying them. What do? It's part of the assessment. We're going to assess it. It's going to be a balance on their account. Again, this leads to they're not paying it. We're at the fourth level. What can we do? Now it's kind of not just a bylaw violation issue. It's a collections issue. They're going to get noticed. They're going to start accruing late fees. All right.
Well, and it's every bylaw generally has a provision in there outlining the process or the order that payments are applied in, and typically fines are first. So when if someone's paying their regular dues, they're technically paying off those fines, and then their dues officially become late.
Yeah, so you'll get, no, I didn't mean to pay that fine. I sent my $300 assessment, and that was for my assessment. To Lee's point, it's what we look for. We call it application of payment language. A lot of times, certainly in condominium associations, it's going to be in your section 2, and it's going to say payments received shall first be applied to attorney's fees. Because we write the documents. Attorney's fees, fines, late fees, and then assessments. Assessments are the last things that is applicable to. Even if you don't have that specific language, I think a lot of times our position is going to be, it's kind of just an accounting mechanism, first in, first out, which is, yeah, but that fine was assessed and the late fee, and then your assessment came due. So when we got your payment, we first applied it to these things. I'm not an accountant, but that's, yeah, that's exactly right. First, yeah. So, to that point, that's how you look to collect those. I will state, judges don't like collection cases that are just fines. So are we legally entitled to do it? Absolutely. Do you need to do that sometimes? Yes. We're trying to enforce the bylaws. We're trying to enforce the bylaws without, frankly, more expensive mechanisms. But if I got to go in front of a judge and say, judges, $300 worth of fines, they've paid all their other assessments, and $600 worth of late fees related to those, judges don't like that. So if you're in collections with my office, you're going to hear from us, hey, we're going to make sure that you did the fining properly. We want to see the notices. We want to make sure that there was notice and an opportunity for a hearing, that we did those things, because, man, this balance looks like it's just fines. So that's not to dissuade you from doing it, right? Just kind of know that if it gets into collections, boy, judges don't like that. The purpose of a fine is corrective. We've talked about this. Fines should not be levied indefinitely. And once the greatest fine on the schedule has been levied, it is likely that additional corrective action is needed, i.e. an injunctive court order. Fines are not a revenue stream. Fines are meant to change the action, the activity, whatever the case may be. If you get to the fourth level of fine, this is our general advice. It's not working. Whether the person's paying it, that's definitely not working, and not doing the thing, or they're not paying it, right? Your fines are not working. We need to do something else. And so this is when we start talking about a court action, which is actually not our next section, but we'll get to that. Self-help and abatement. This is another one of our bylaw enforcement mechanisms to help cure these bylaw violations. Self-help must be in the recorded documents. An example, the violation of the condominium documents shall give the association or its duly agents the right, in addition to the right set forth above, so other litigation, fines, whatever the case may be, to enter upon the common elements or into any unit where reasonably necessary, and summarily remove and abate at the expense of the co-owner in violation any structure, thing, or condition existing or maintained contrary to the condominium documents. So this is, rather than sending notices and demands to the co-owner to fix the violation, do the right thing, this is the association. probably KS management. Going on to common elements, going on to units to fix the thing. Pink flamingos. This person has dozens of pink flamingos in their front lawn. It's a violation. It's not only unsightly, it didn't get approval. How do we do this? Ben, can we go remove the pink flamingos from the general common elements? Yes. But let's talk about site condominium. It's in their front lawn. Can we go onto their property and remove those pink flamingos? This is what self-help and abatement is about. And so, do you have the legal right to do that? Is it in your documents? It needs to be in your documents. Yes. Is it advisable all the time? It kind of depends on the situation. We're going to assess the cost to the unit. Here's a big one. Cannot breach the peace. Ben, can I go onto the property and remove the pink flamingos? You can, but you can't breach the peace. And breaching the peace is ultimately the co-owner is going to call the police, the authorities, and say, this person's trespassing on my land. They're trying to remove my property, order them off of my property. Now, when the officer comes out to confront Lee in the co-owner's front yard, removing pink flamingos, and Lee says, well, our master deed and bylaws says we can, officer. Officer Johnson is going to say, that's a civil matter. That has nothing to do with me. Lee, get off the property until somebody gets a court order that says who can do what here. Lee, KS, association, don't go onto this co-owner's property, right? So that's what we're talking about with breaching the peace. How do we avoid that? Again, a lot of this is going to be a case-by-case analysis. I'm using pink flamingos because it's entertaining and it's easy. Anyone can run onto there in 5 minutes, pluck all those up, take them off, send a letter to the co-owner saying, we've got your pink flamingos. If you don't come and retrieve them in 7 days and pay the storage fees, we're going to dispose of them, right? Yeah, something along those lines, right? So breaching the peace, Ben, can we do that? Well, yeah, you can. We got to breach the peace. Do you know when they work? Do you know if they're going on vacation? Do it then. And that's not being cute. I'm telling you, if they're not there to raise the issue, do it when you know they're not home. But there's some other more serious things, right? Someone has installed a fountain, and we had a very expensive case involving a very expensive fountain. Could the association have just gone on and removed this fountain? They had the right to do so, right? That's not the type of thing you can do in a day. Or even if it is, that's serious equipment. this was a $40,000 fountain. It was not it was a big 12-foot pole. So, can you physically, could you do it? Yeah, probably. Practically speaking, it's just not going to work, right? So kind of when do we talk about utilizing self-help and abatement, right? Fair to maintain landscaping. Could we have the lawn mowed? Could we remove the pink flamingos? Fair to heat a vacant unit. This is kind of a big one. Hey, I got some snowbirds and they're south for 6 months. And we're pretty sure that they didn't leave any heat on, right? Especially attached condominiums. This is a big deal. This is a lot of what KS and the Makower law firm deal with is water intrusions. Yeah, let's get in there. Absolutely. And again, a lot of these documents are going to talk about entry into units with reasonable notice, except in the instance of an emergency. And if we're talking about water intrusions, I'm going to consider that an emergency almost every time. Certain parking violations that merit towing. Let's go on to our next one. We get this one a lot. A lot of restrictions have no inoperable vehicles, no vehicles without a current registration, right? And a lot of times boards aren't, I don't think, going out and looking necessarily for those things, but the vehicles, it's the old Ford Impala that's been sitting there with only 3 wheels for months, right? This is an inoperable vehicle. So we need to check the self-help language in the documents for towing authorization. Here, I really prefer, and we are going to require that your documents say the association can tow vehicles. I want to see your legal right to do that. And then in addition to what your documents say, we've got to comply with the state law, which requires prior personal notice or special signage. Let me speak to what constitutes personal notice for the towing of a vehicle. Ben, we tagged that vehicle with notice 3 days ago. Nobody's contacted us. Is that personal notice? No, it is not. I need you to put that notice in the co-owner's hand and say, if you don't move that document, that vehicle, we're going to tow it in 3 days. Or have Lee do it. Don't use the board.
We have to serve it.
What if you don't know whose car it is?
I'm sorry, what's that?
What if you don't know whose vehicle it is?
And then that's a problem, right? Because how do I get personal service on that? Absolutely. So but tagging it is still not going to do it. So there, it's unfortunate. We're going to have to talk about a court order. We should be, I would think, I mean, unless it's the old Impala that maybe doesn't have the VIN, we should be able to find out whose it is to some extent. We're going to go through some efforts to determine whose vehicle it is before we talk about towing and before we talk about the expense of litigation, right? So we can assist with that. There's got to be some inkling of a way to find that out.
And we can, as a management company, we've done that before. There's means through the Secretary of State that we can, it's like a $1 fee that you pay, and you can search a license plate to see who the registered owner is. A lot of times if you contact the local police, they'll come out and they can run the plate, and they may tell you an address or something that kind of indicates who it belongs to. They typically won't just tell you straight up, but they'll give you some kind of assistance with it too.
Yeah, so we're going to make efforts to find out who's it, some pretty reasonable efforts to find out whose it is before we engage in that. So again, personal notice, not just tagging the vehicle. Special signage. And this is again what a lot of our communities have. Some of them maybe don't like it. I understand that, but again, this is the statutory requirement. This is what the state law says with regard to towing vehicles. What you have to have, what you have to post. You need to display at each access point. You got 2 drives coming into your community. It's got to be at each of those. Don't just put it down here. If no curbs or access barriers every 100 feet. 2-inch letters, unauthorized vehicles will be towed away at owner's expense. Name and number of the towing company, because people need to know how to retrieve the vehicle that you've towed. Bottom of the sign is at least 4 feet from the ground. These aren't terribly difficult. They're not draconian. I once had someone try to challenge, I think the signs were 3.5 feet above the ground, right? The court didn't buy it, which is the notice was there, the sign was there. That's a technical deficiency that I'm not gonna ding the association with. But we really, given the value of vehicles, the importance of vehicles, and the fact that people are real willing to take legal action with regard to their vehicle being towed, we want to make sure that we're being really careful with towing vehicles.
Excuse me,
Sure.
on that point, going back a little bit to the fines, we have one resident who, you know, we send out the letter, you know, the first letter, and then the second, they usually have to be hit with a fine before they comply. Well, then they'll comply for, you know, maybe a month all over again. Can we go ahead and hit them with the next fine?
So this is a distinction between a continuing violation and a repeat violation. Okay. What's a continuing violation? Co-owner Lee painted his deck pink because that's his favorite color.
He's actually colorblind, so he didn't know it was pink.
He is. Right?
And so we send the notice, we hold the hearing, Lee doesn't show up to defend himself, and we issue the decision that there's a violation, and we're gonna proceed with the first fine level, which is 0, a warning, and you have 14 days to cure that. A pink deck, I'd probably give 30 days. But Lee doesn't do it, right? Do we have to hold another hearing? I would argue no. You held a hearing. The violation has continued. Now, I'd like to see your policy specify so that co-owners know this as well, that continued violations and the notice that you send them, the determination that you send them should state, if this is not cured within 30 days, the next fine will levy, because you've already made a finding. The deck is pink. It's not approved to be pink. It needs to be removed. there's no point in having, nothing's changed. We don't have to make any new findings of fact. This is to be distinguished from a repeat violation. Co-owner parked their boat in the driveway. It was there for a week. We sent a violation. There was a hearing. It's the first level, zero fine, right? Warning. And that goes out and they get the determination. The next week, the boat is gone. 2 months later, the boat is there again. It's a new violation. Got to have another hearing. Got to issue another. Boy, Ben, that sounds like all work. It sounds like a lot of meetings. It is.
So maybe, what if they move it out into the street for, you know what I mean, or just move it?
So they're being cute, which is I'm going to cure this. I'm going to cure the violation. I'll move it off the properties. I'll move it into the Wendy's parking lot for a night.
Yeah.
I'll move it back. My boat's here 6 out of 7 days. Fines are not going to work in that case, right? This is again, there's rarely a requirement that you march all the way through your fining procedure before you proceed with other enforcement. A lot of times we have co-owners and even their attorneys raise this issue when we do file litigation, which we're going to talk about next, which is, hey, you didn't give us notice in a hearing, you didn't levy all 4 fines, right? You can't sue us for an injunction. You didn't do these things. We don't have to. Normally, again, part of I think some of the language that I read previously was, shall give the association, and this has to do with self-help and abatement, but it's similar, right? In addition to the rights set forth there above, this is not an exclusive remedy. We have various rights. There are some things that we're not going to bother with a fine. We're probably going to proceed with litigation pretty quickly. I mean, very serious violations, but I'm not going to send a guy a fine because he fired his gun in his unit. I'm going to file a lawsuit and a police report, right? So again, yeah, this is why I'm saying this is general information, because every situation is going to be a little bit different, and there's no requirement that you march through the fines. If it's a serious enough, if you send it over, we'll have maybe a discussion. I'll have a discussion with Lee and his team about like, do we want to jump right to litigation right away? What other efforts have been made? What's the history of what has happened here? So we're going to take that into consideration. But sir, you're absolutely right. Because someone play those games, they could. But towards the question of, Ben, do we have to have a hearing? Again, you need to give yourself some thought. Has anything changed? But nothing's really changed with regard to the boat. It was there, but it has changed. They moved it. Now it's back. It's a different day. It's a new violation. If it's sat there, please remove it in 7 days. If you don't remove it in 7 days, well, now it's a continuing violation.
But there's not any definitive hard line. This is a case by case basis, right?
It's a case by case basis because, to the gentleman's question and everybody's point, co-owners find creative ways to violate the bylaws. And they find creative ways to argue that they're not violating the bylaws and to get around the fines and to get around having to pay for our fees for letters and those different types of things. So again, these are general tools that we're going to look at. Everyone's probably going to we run into a lot of the same ones. The reason I'm able to give these types of explanations and examples, we run into a lot of the same stuff. Chaos runs into a lot of the same things, right? But there's always a new wrinkle for a lot of them.
Well, and it really is contingent upon what it is. Like Ben said, you have litigation. You're probably not going to do that for trash. Like someone doesn't remove their trash can by 6 a.m. the next day. You're not going to file a lawsuit for that generally. You're gonna have Ben might say yes, he likes litigation. So
we have an incident for Easter. The same person parking. There's like 7 parking spaces, on our street. They got cones and put all the cones in every space. Yeah. Blocked all the parking out so other people couldn't have family over and park there. I did run over there and get the cones, but I could have.
You could have, because
that surprises me.
Assuming that the road and the parking area that you're talking about is a general common element, that's a nuisance and abatement right there.
Yeah.
Go over and take, again, in that instance, that may be a little bit different. If they bother to call the police on Easter morning, is the police going to tell you to put the cones back? I don't know. So you get, you're the board, you're in the field, you know how these people are going to react, or how your co-owners are going, you know, how do I not, you know, this is unfortunate. They shouldn't have done that. How do I not ruin my Easter morning? How do I not engage with them? So, you know, that's a tough one. Because would you have had the right to go out and remove the cones? Absolutely. Easter morning, it's a tough decision.
You had to read them. They don't run that fast.
Yeah, right. So let's get into now maybe you've tried fines, self-abatement's not an issue or not an option, or you've tried it and it's not work, and we're talking about breaching the peace. Now we're talking about lawsuits. Of course, this is a lot of what I do. It's going to be a circuit court action, right? A district court is a lower level court. It doesn't have jurisdiction over what we typically need, which is injunctive relief. A court order that says do the thing or stop doing the thing. District courts don't have the jurisdiction to do that. So we're going to go to the circuit court. So we've got a district court, the circuit court, and the court of appeals. If fines do not bring about the desired compliance, condominium documents should permit circuit court action to obtain an injunction against the co-owners for the violation of the condominium documents. The injunction may prohibit or require an action. For example, require removal of an unapproved fence, and in the absence of such removal, allowing the association to enter into property and remove with costs assessed to the co-owners. A violation of a circuit court injunction can carry with it court fines as well as potential imprisonments for contempt of court. You know, Ben, we've sent them letters. We've done all this stuff. They're not doing the thing. They have the money to go into court and fight us with it. What difference is the court order going to make? Well, first of all, that's kind of, if you've gotten that far, that's what you're left with, right? I don't have much else to offer you then. We have to use the system. And the system is we got to go to the court and we got to explain why this is violation and ask the court to order them to remove it. And if they don't remove it, this is generally what we're asking for. Remove the fence within 30 days. And this is what I want in my judgment. If the co-owner doesn't remove the fence within 30 days, the association shall have the ability to enter upon the property, remove the fence, and assess all costs back to the co-owner, right? So again, litigation is expensive for you, the association, but condominium documents at least, and we'll talk about homeowners associations in a second, are going to allow you an award of attorney's fees against the co-owner. So they're going to pay, if they decide to get an attorney, their attorney, and they're going to pay hopefully most of your fees as well. But the other thing is besides the court order, but they don't do it, we could do it, it's going to be expensive. Judges sure don't like their orders to be violated. That makes them very upset. And so when we talk about court fines, right, this is above and beyond the fines that are in your documents that we talked about before. This is a penalty imposed by the court to encourage the co-owner to do what the court has already ordered. Imprisonment for contempt of court, it's a possibility. The court rules provide for it. I've never had anyone placed in prison for violating a judgment, even related to a bylaw violation. It is a possibility. Is there, you know, if it were a safety concern, could I see that being the case? Absolutely, right? A lot of times we're talking about kind of, and I frame it in you know, modifications to units or modifications to common elements, and we got to fix these things and aesthetics. But there are also safety issues. Right. Someone who's been ordered. I mean, I've obtained orders prohibiting, you know, a co-owner's son from coming onto the property because of threats, danger, those different types of things. When we're talking about a lawsuit, the first thing you as a board can think about it, but management and definitely your attorney needs to determine if you need co-owner approval to proceed with litigation. So this is what my shorthand is: litigation hurdles. And so you need to check all governing documents, including the articles of incorporation. A lot of times we default to just looking at the master deed and the bylaws, but the parent governing document of your association is your articles of incorporation. Because again, you're corporations, right? You're nonprofit corporations, but you're running a business. And so we need to look and see if these restrictions are in there. There are two types of common restrictions that we find. A standing prohibition against all civil litigation. The board cannot engage in any civil litigation without the approval of the majority of the co-owners, 60% of the co-owners, 2/3 of co-owners, whatever that restriction says. And the second that we see is a prohibition on spending motivation for litigation without co-owner approval. So I'm sorry, the first one is just a flat out no civil litigation, which we don't see very often. The second one is you can't proceed, the board can't proceed with litigation without co-owner approval. And when we're looking at those, we're looking for, is there an exception for enforcing the restrictions? So a lot of times there's a long section in either your articles of incorporation or your bylaws. And if you have the ability to search the PDF, if you search for litigation, it'll pop up. And it says the board of directors does not have the authority, with the exception of bylaw enforcement or collections, to commence any civil litigation. These types of restrictions were put in starting in the late 80s and the early 90s. You still see them in a lot of documents to make it difficult, if not impossible, for condominium and homeowners associations to sue the developer. The developer's the one who drafts these documents. They're protecting themselves. This is the point of those types of restrictions. But it makes it difficult for you, the board, to enforce a lot of your other rights. If it's straight out prohibition, what are you going to do? How are we going to address these types of problems? Your bylaws are almost, your restrictions are almost unenforceable. If there's exceptions for bylaw enforcement and collections, right? You, the board, are the one that get to make the decision, right? We're gonna proceed with litigation on this bylaw violation. We're gonna proceed with litigation on collections. But anything beyond that, you need co-owner approval. And these are couched in the form of to avoid improvident litigation, right? This idea that the board is going to unwisely spend everybody's money proceeding with litigation on a $5,000 a landscaping dispute and end up with a $20,000 legal bill, right? This is how these are painted, as protecting the community against these things. In practice, they don't really do that. What it does is you don't have as many options to pursue your legal rights with regard beyond bylaw enforcement or collections. But you can spend just as much money with my firm or your chosen law firm on bylaw violations as you can suing a third party, right? So, for this reason, if we're talking about litigation for bylaw enforcement, that's what our seminar is about here. We need to check for that. A lot of times there's going to be a carve out, and just generally speaking, because the approval level is just as high often as the amendment level, it is our recommendation that those provisions be amended out of your documents, because they're really handcuffs in your ability to operate your organization to the fullest extent of the law. Some of the things we want to see before filing a lawsuit: has the attorney sent a cease and desist letter? I like to see, except in very serious cases, I like to see a letter or two from the association. I like to see a letter from our office, right? When I go into court and I have to have litigation on the pink flamingos, which you think, well, why would somebody fight about that, Ben? They will fight about their pink flamingos. And courts oftentimes don't like those types of fights. They're circuit courts. They think they're above these types of arguments, right? But the circuit court is the one who has the jurisdiction to give me that order, right? I want to be able to show the judge that we're the most reasonable party in the courtroom. Judge, I sent him a letter. The board talked to him. The board sent him a letter. Management sent him a letter. My office sent him a letter. They're not doing what they need to. You're my last resort. This is not just an overzealous association running into court over the pink flamingos. We've done what we can. We need your help now, Judge. Do we have evidence? The pink flamingo is an easy one. Go out, take the pictures. Take a picture, take the video. That's an easy one, right? It's the more difficult ones where we need to have more serious conversations about evidence, odors, sound. These are difficult evidentiary hurdles Well, I've got a recording. Well, okay, but I don't know what you did to amplify that recording. We're going to have arguments about decibel meters and all these other different types of things. What type of evidence do I have on that? And those types of kind of more amorphous type of action violation as opposed to material violations. The car's been parked there, the pink flamingos are there, whatever the case may be. I'm going to need a witness. I'm going to need witnesses. My preference is witnesses. The radio is on at 3 a.m. in the morning to the point where I cannot sleep. It's interrupting my workday, whatever the case may be. And so those co-owners who are filing complaints with the board, what are you doing about this? And the board has tried fines and we've tried letters and everything. And now we're contemplating the serious option of litigation. And the board approaches those co-owners and say, we're going to do this, but we're going to need you to serve as a witness. You may have to come to court or at least provide us with a written statement pointing the finger at your neighbor and accusing them of the wrongdoing. Are you willing to do that? Oh, well, I don't want to be involved in litigation. I don't want to put my name out there. Well, then we're going to have a hard time addressing this because again, those types of violations, a lot of times we're looking at the nuisance and annoyance provision that almost all of you have. What constitutes a nuisance and annoyance? I need people to be able to say, this is interrupting my life. This is interrupting my quiet enjoyment of my property. And if people aren't willing to step into court and testify to that, we're going to have a hard time getting there. Temporary restraining order. Temporary restraining order and preliminary injunction for emergencies, which should be our next one, Lee.
I love that. There we go.
A temporary restraining order, what we refer to as a TRO. A temporary restraining order is it's an order that's only valid for 14 days. So this is an emergency. This is, I'm going to go into court. I'm going to file a lawsuit. I'm going to file a motion with the TRO, and I'm going to go to the judge. And I'm going to say, Judge, this is such an important issue that I need you to give me an order today without hearing from the other side, right? They don't get to come in and defend themselves. This is that important, Judge. Give me an order right now. So that is a very serious request to a judge. Where do I see these most often? Water intrusions. Then the downstairs owner is complaining like there's water leaking from the upstairs unit, and that co-owner is not giving us access to the unit. They're home. They won't answer the door. We can't self-help because they've locked it. They won't let us in. What can we do? Now I'm talking about potentially a temporary restraining order. I'm running into court saying, Judge, give me an order that says I can go into their unit and address at least initially this water intrusion, right? And that court order is going to say that I can bring the police with me if I need to enforce that order, right? So it's not just Lee standing with a piece of paper saying, well, the court said, and so then we're going to look at a preliminary injunction. A preliminary injunction is, I don't know that I see them too often in bylaw violation. A preliminary injunction then is an order that stays the activity during the course of the case. And so it's really transforming that temporary restraining order into something a little bit more permanent while the case is pending. Again, a lot of times, using my example of a water intrusion, we're going to get in there, we're going to make the fix. The case is probably kind of done at that point. Now we're going to continue litigating. We're going to wrap it up talking about attorney's fees. Balancing of the equities, likelihood of success for the association, any harm to the public. These are some of the standards that we need to convince the court of to give us a temporary restraining order. Balancing the equities, Judge, it's not fair for the lower unit owner to wait the length of litigation, 3 months, 6 months, a year to fix a water intrusion, right? So those are conversations that we as attorneys would have with you, the board, if we're talking about seeking a temporary restraining order. Water intrusions is the best example that I can give with regard to bylaw violations. The only other one that I deal with occasionally is pink flamingos. That's a hard one to sell. construction or modification of general common elements or unapproved construction on a condominium. They're out there, you know, we told them they can't build the garage. They're starting to build the garage. Then I'm probably willing to try a temporary restraining order, because the fact of the matter is once that building gets up, a judge is going to have a hard time ordering it be torn down. So, you know, if you have not approved some modification and you see that modification taking place, we need to take, depending upon the scale, right? If it's a wreath on the front door, that's one thing. If it's somebody, what's that?
Doghouse.
The doghouse. All right. So we'll talk about matters of scale, but Ben, we didn't approve a separate 2-car garage. We want to stop that pretty quickly.
And immediately tell your management company.
Yeah. You probably want to let them know, and they'll get a hold of us. Attorney's fees are recoverable if a condo association is successful. Subdivisions, check your declaration. So again, we're going to go back to the act. We've got our section of the Condominium Act here. In a proceeding arising because of an alleged default by a co-owner, the association of co-owners or the co-owner, if successful, shall recover the cost of the proceeding and reasonable attorney's fees as determined by the court, to the extent the condominium documents expressly so provides. But wait, Ben, it says that the association of co-owners or the co-owner could recover their reasonable attorney's fees, right? It does, but it also says to the extent the condominium documents expressly so provide. So again, I mentioned earlier, most of the documents, certainly the documents that we draft, most of your documents are going to say that the association is entitled to an award of its attorney's fees, but it's not going to say that the co-owner is entitled to an award of their attorney's fees. So that's a little bit document driven, as determined by the court. That's important, because the court's still the entity that determines the award of attorney's fees that you, the association, are going to be entitled to. You know, and so I'm going to tell you that you're entitled to every dollar that you've paid me, because I'm an excellent attorney and we've gone in and we were successful and my fees are reasonable and just. But the court is the one that gets to decide that. And there's been more than one court that we've had to appeal to make sure that our client got an award of their attorney's fees as opposed to just nothing. And that is not just solely at the judge's discretion. There is case law that specifies how courts are supposed to determine what a reasonable fee is, not only the hourly rate, but the work that is done in that. So I think we have a pretty good track record of getting the bulk of our attorney's fees as an award for our clients. And the great thing about that is we get that award, you have the ability to assess it to their unit, right? So and potentially foreclose upon that unit. A lot of times when I get a judgment, a money judgment on behalf of a client, I got to hunt them down. I got to find bank accounts. I got to seize vehicles. I got to seize boats. You guys have, associations have different collections mechanisms. Subdivisions don't have the benefit, like I stated earlier, of the Condominium Act. That is a statute that a law that says the association gets an award of attorney's fees. Subdivision declarations are a matter of contract. And so if that contract does not say that the association is entitled to an award of your attorney's fees, you, the subdivision, are not entitled to an award of your attorney's fees. So now everybody's just paying to enforce the restrictions against the violator. And you know, that cost is the benefit of the organization is that cost is spread out over all of you. Maybe everybody's only paying $100 and they're paying tens of thousands of dollars to their attorney, but the wrongdoer, right, still doesn't have the ultimate penalty, which is we wouldn't have incurred these fees in the first place if you hadn't done the wrong thing. What about attorney's fees if there is no lawsuit? There is no automatic right to assess costs unless explicitly provided in the recorded documents. So this is what I would refer to as pre-litigation fees. Ben, we had to pay you, whatever my hourly rate is, $350 to draft the letter to that guy about his pink flamingos, and he cured, but he should have done it when we sent him letters instead of having to pay you to do it. Can we assess your fees to the co-owner? Only if your documents say you can do that. Many documents, particularly older documents, simply indicate that the association is entitled to recover costs and fees as may be determined by the court. So if you look at your enforcement, your remedies sections in your master deed and bylaws, it's going to be there. I have to go to court, and the court has to be the one to determine whether or not you're going to get an award of your attorney's fees and what that is. And a lot of times, I think associations, they kind of get used to, especially if all they're doing a lot of times is collections, because again, we absolutely, definitely in condominiums, we get an award of our attorney's fees. There's really no question about that. Bylaw violations, a lot of times we got to go to the court. Modern provisions permit the association to assess costs automatically. So again, the type of language, violations and costs, damages, fines, expenses, or actual attorney's fees incurred or levied by the association, and enforcing any of the document provisions may be assessed to, secured by the statutory lien on the unit, and collected from the responsible co-owner. This specifically includes actual costs and legal fees incurred by the association in investigating and seeking legal advice concerning violations and responding to and defending actions related to violations in small claims court or any other court of competent jurisdiction. This is, again, you may have seen the co-owner who is upset with the association and management. They file a small claims case against the association and management or a board member because they don't want to pay an attorney to have a legal fight, and they think, I'll avoid having attorney's fees by filing a small claims. Well, the association needs to be represented by an attorney, so I've got to remove it from small claims. But now we're just defending against this. You're paying money to me, my firm, or your chosen law firm to defend against this, frankly, frivolous lawsuit filed by a co-owner. Ben, can we recover? But Ben, we were successful. Yeah, but all we were doing was defending against the association, and your documents don't have language that you're entitled to an award for defending against that. Because a lot of times when we get in that situation, I ask my clients, are there any active bylaw violations? Because if there are, we're going to file a countersuit so we can try to get an award of our attorney's fees. But if you don't, it just becomes expensive defending against these frivolous little lawsuits. Tenants. This is the bane of many of my association clients. The Condominium Act allows condominium associations to evict tenants who are not complying with condominium documents. This requires an initial letter to the landlord sent by certified mail. After 15 days, if breaches continue or the association believes they will continue, the association can escalate eviction processes. So a lot of my certainly attached condominiums, they have investment properties in there. There's an absentee landlord who's just got a tenant in there, and their tenant has become the association's problem. This really needs to be the co-owner's problem. You need to make this the co-owner's problem. That means violation letters to the co-owners. That means, again, going back to kind of updating your documents to make sure that you have enforcement language, because if you can assess pre-litigation fees, you're not only sending the letter to the landlord co-owner, you're assessing that cost. Now their tenant is costing them money, and that is what they don't want. So that's how we incentivize them policing their own tenants or just getting better tenants. But if it is a repeat or serious violation, we can seek to evict the tenants. This is, again, kind of going to be a little bit of a case-by-case analysis. Ben, can we evict them? Yes, we can evict them. What is the violation? They keep putting those pink flamingos on the front lawn. Do I have a right to evict the tenant for the pink flamingos? Yes. Do I think a court is going to give me an order evicting the tenant for continually putting pink flamingos in the front yard? I do not. So again, we kind of want to, you have this option. Then the tenant fired a gun in the property, in the unit. That's not a random example. I've had that happen. We're going to send a letter to the co-owner saying, hey, you need to evict your tenant, and we're going to send a copy of that letter to the tenant with a 30-day eviction notice. We're going to start the procedure right away. And that way, if the co-owner doesn't start their own eviction process, we are going to pursue eviction. So you know, when clients ask me about eviction, I'm looking at one of two things. A really kind of well-established, long history of repeat violations that maybe aren't that serious. And it's not, but it's They don't do this, they don't do this. Then they're like, this is just a problem tenant. They just don't follow the rules. I'm comfortable seeking an eviction based upon this is a continuing, ongoing problem or something really serious. We're gonna seek an eviction. Subdivisions, HOAs, no statutory right to recover attorney's fees. Language must be in the governing documents. We talked about this before. You need to look at your declaration or your bylaws to determine whether or not you have the right to recover attorney's fees. I have for a number of my homeowners association clients of late adopted bylaw provisions allowing them to assess enforcement costs. And a lot of times in associations, homeowners associations, some of these recreational associations that we represent, the ability to amend the bylaws is a lot easier than it is certainly to amend the declaration, or even for condominium associations to amend their bylaws. A lot of times the board can do it on their own unless it comes to the assessment provisions. So we can look into doing that. Fines and self-help must be in the governing documents. Again, the homeowners associations that are not condominium associations, they don't have the protections of the Condominium Act. It's a contract issue. If it's not in the four corners of that document, and we don't have the ability to adopt rules that allow for it, can't do it. Many subdivisions need to amend their documents to support enforceability. So that is my presentation, but I am happy to stand up here and answer specific questions, general questions about any of these issues or your community.
Can I ask a question?
Of course you can, Lee.
So you were talking about lawsuits. Some documents require co-owner approval for the association to actually file a lawsuit. So typically you would not discuss co-owners violations with the general community in an open session. You wouldn't say Chris has an open violation. So how do you get approval from a community to pursue a lawsuit against Chris without disclosing to the entire community that he's a problem?
I'm going to disclose that Chris is a problem.
Okay.
Yeah, so so the general practice of we don't discuss bylaw violations in open meetings is not one required by law. That is more of a neighborly practice, right? We're not going to discuss that. It's between the association and that co-owner. We're working with them towards resolution. Hopefully that is what you're doing. But that is not privileged information. That is not confidential information. That is not protected information. You know, in the legal sense. Now, if someone asks, I won't go afield on that. There is no prohibition of standing up and saying, this is why we are asking you to approve this litigation. Chris, the Blue Flamingos, you've all seen it. We've made these efforts. He's not doing it. If we're going to deal with this, this is what needs to happen, right? And again, it becomes tough because you're asking these people to spend more money, at least up front. Again, hopefully we're seeking an award of attorney's fees as well. And you have to get that engagement because a lot of times it is a majority. It is 2/3 approval. And if you have to do that every time for bylaw violation, it's a lot of these provisions, again, they're made to be difficult to satisfy. They're made to be expensive to satisfy. You'll spend a couple $1,000s satisfying the requirements to seek approval for litigation. This is why our recommendation is if you have those restrictions in there, rather than seeking approval for the litigation every time, seek to amend the documents to remove that in the first place, right? And again, you got to convince your co-owners, and we can help you do this, but we don't want the board going out and spending our money. There's a reason it's in there, and it says it's protect us from them foolishly going out and spending our money having these legal fights. But they can, and again, most of these have the carve out for bylaw and collection. They can spend the same amount of money on a bylaw violation. They don't need your approval. But now we're talking about a contractor that you have a legitimate dispute with that has tens of thousands of your dollars and hasn't done the thing, and you can't file a lawsuit against them. I can send them angry letters all day long. I'll charge you all kinds of money to send them angry letters, but I can't compel them to do anything because we need to go to court to do that. What's that? I can't, it depends on what it is, right? I can't, if you're running up the fines, then that adds as a lien, right? But a lien maybe doesn't compel them to do the thing that they need to do. So again, I'm, as a litigator, one of the litigators in our firm, right? Of course, Ben, you're a hammer. Everything looks like a nail. But I do think that we do a pretty good job, in my opinion, of advising our clients, a lot of times who are more than willing to run into court, that we need to step back a little bit and we need to talk about what it's going to cost. We need to talk about some of the effects upon your community. Bylaw violation litigation normally not probably going to have an effect upon marketability, meaning when you go to refinance or sell your units, the condominium questionnaire is going to ask if there's any active litigation. I think sometimes it might specify other than collections.
It does.
Does it ever specify other than bylaw? Okay. So I'm going to have to disclose a bylaw violation litigation case to a potential lender. And they're going to ask about what it is. If it's bylaw enforcement that doesn't involve major structural issues, it's not going to have any effect. If it's litigation with a contractor, or if somebody's suing you, the association, it may be difficult for people to refinance. It may be difficult for people to sell their units, right? And so I'm trying to be very cognizant of advising my clients. We got to go into court on this. We're gonna have the conversation of, did you send the letter? Why don't you let me send the letter? Have we tried any fines? Again, it's a matter of scale. You don't have to exhaust all of those. It kind of depends upon how serious it is. It's difficult because I think a lot of times it feels like, Ben, I've got to jump through all these hoops and they just get to do what they want. Yeah. Unfortunately, we're the ones that have to follow the rules. They're the ones who are breaking the rules.
Do you recommend having police presence if you have the tow vehicle? A lot of times,
Yeah.
Tow company will have police come out and look at it.
Okay.
Yeah. I defer to, I've never been on, I don't know that we've ever said, yeah, we have the police there, because, a legitimate towing company's got the license that they need to do that. But if there's a reason to have
cover
it.
their bases, like they're not necessarily required, but a lot of the tow companies I've worked with, they're like, I'm protecting myself. So they have the police come out there and look at it and sign off on it before they tow it.
Okay, I mean, I've had a situation in our complex in Allen Park where Allen Park Police advised me to definitely have police presence in case you get the angry owner of the vehicle out there, causing a rumpus.
Well, I've had times where like
Breaching the peace. Yeah, that's exactly what that is.
the owner said, hey, your tow company did all this damage, right? So having the police there looking at it, making sure they take pictures of before it leaves, that way they can cover their bases, alleviates a lot of those concerns.
Yeah.
Any other questions? Anyone online, Chris, that has questions?
I got one. Well, we had a shed policy to our bastard heat, or whatever you want to call it, before Cass took over. So we've had people in our subdivision put any kind of shed they want up. It specifies it's supposed to be match the siding on the house. It's supposed to have the same roof pitch. It's supposed to have a slab rat wall. So we've had people come in and just buy some shed and it doesn't even match the house or anything like that and put it on dirt. And I've talked to Cass about it, and she's in the process of trying to get something to go on, but so what legal thing can we do to these people then? Do we just have their shed taken away, or it doesn't match the house? It's laying on dirt. It's,
Right.
what I mean?
Yeah, you could. If you think you can get in and out of there quick enough and remove the shed. Yeah.
People are sort of new to our association.
So
They moved in probably about a year ago.
Mhm.
It still sits
Right.
there. What? They didn't ask, they didn't know they had to ask. I'm going, you move into an association, you know what I mean? There's an HOA, so there's bylaws, you know what I mean?
Well, as as someone who practices in this every day, and as someone who lives in an association, we do assume that, right? But I've also had good friends who have moved into a house, but I had no idea it was a condominium. I had no, you know, I'm like, but so you're getting a lot of that. But here's what I'm hearing, which is we allow sheds and we have standards for approved sheds. And so if you meet those standards, you probably don't even have to ask the board for approval because we've set a standard. And I have this for a lot of things, because a lot of times, most of these documents are going to talk about, you know, no exterior modifications, no additional structures on a unit without board approval. And so, Ben, can we just set a standard that'll be a little less work for us? Yeah, absolutely. Here's our standard, and it's published, and everybody gets it. They probably get it as a welcome packet, right? And those different types of things. And so you don't have to do that. And the board can look at what, drive around and say, all right, these comply, this one doesn't. So again, I think we want to be the most reasonable party in the courtroom, that because I'm always, even though I want to avoid, I'm always looking for when I got to stand in front of the judge and explain myself, my client. I think unless you know, start with a letter, send another letter, send another letter, right? Let's
You gotta go through the stuff.
let's try and engage that. But if they don't, I think you would be, unless you know they're going away for a week.
Well, I'm not saying.
Yeah.
Go on their property, tear it down.
Yeah. This is where if they're just refusing to comply, now we're seeking a court order. Again, at their cost, we're going to ask for an award of their attorneys, condominium or homeowners association. Homeowners. So again, that it becomes tough. It becomes real tough for my homeowners associations. Do you know if your documents entitle you to an award of your attorney's fees?
No.
You don't know, or yeah. So because that becomes, Ben, what are we supposed to do about this? And the answer is, you still have an obligation to do it. You have an obligation to, the board have an obligation to enforce those restrictions, but it's going to cost money. You're right, it is. And then assessments are going to go up. You're right, it is. And kind of to Lee's question earlier, when the following year we're going over the budget and we look at the budget and it's $5,000 higher than what we had budgeted for legal,
Right.
and even probably before that, we're going to indicate. We don't have to point, we don't have to call names or anything. Well, that had to do with the case of association versus co-owner. Told everyone who the problem is. When you file a lawsuit, that's public information. Anybody can find that, right? So it's not defamation. It's not bad mouthing anyone. That's a fact. We had to sue this co-owner to get them to comply, right? We're probably talking about, depending on the severity of it, some type of notice to the community beforehand so that you hate for people to be surprised at closing or just before closing to learn that their association is in serious litigation. That's not often the case for bylaw violations.
Right.
Yeah, there it's a matter of kind of public pressure, but know that we're willing to do it, and that it costs everybody here to do it. All of you who have complied with the restriction know that you're having to pay more in assessments because your neighbor didn't.
I know, and a lot of people follow the rules, but some people they buy a kid shed. It doesn't do anything with their house, but it's there. You know what I mean? And then what are we gonna do after everything's sitting there? I mean, that's. You let one slide, then they all gonna see,
that's exactly right. And that was one of the points that we made, which is now everybody's going to point, well, but I found 3 or 4 others in the case. And this is okay. I have to do it. You're required to do it. And this is a conversation that I got to have, especially with my subdivisions, which is, if we enforce this one, then I have to enforce all the other ones as well. And by not doing that, you put yourself in jeopardy, the association in jeopardy, by someone filing a lawsuit against the association, compelling you to enforce the restrictions. So you're spending money one way or the other. So I would err on the side of, let's spend money doing the thing that we're supposed to do anyhow, instead of defending against someone trying to compel us to do the thing we're supposed to be doing.
Isn't it a code that a shed has to be put on a slab? Isn't that a general building code?
It depends. That's gonna.
Some say rabbit, which I think is.
And the court should check with your city.
That's gonna be municipal.
It's in our an amendment to our bylaw.
Yeah, you're
I'm saying it keeps notifying your city that that building is not up to code, but the city violates them.
it depends on when you, two things. It depends on what the code is, right? It may or may not be.
Yeah, it's an access building, what do you wanna call it?
Right. And like anything else, your municipal employees are probably overstretched. And so, you know, even if they kind of issue something, the level of enforcement that they are willing to take might not be that high. You know.
Okay, I work in a district. So anyway, so my takeaway from this whole thing is that we need to make sure that our bylaws comply with all these requirements. Now, the three of us sitting here, none of us have a law degree. And who on earth is supposed to sit down and read these bylaws or whatever and determine?
Condominium?
Yeah.
Yeah.
Yes, condominium, yeah.
Your bylaws probably comply with at least these, you don't think you have?
We have the original bylaws
They're
31
30-some
years
years
ago.
Do they not have it?
We were having discussions that we need to almost have you guys scrap them and rewrite them. I mean,
Happy to do that.
Oh,
We
yeah.
do that pretty frequently.
and all the installment payment. That's been
Yeah.
I mean, we're very aware that it needs to be.
You know, but when you talk about the cost of a document amendment process, right? You may have the ability to put that into perspective for your co-owners. We're going to spend, I don't know what our fees, I don't do any of our document amendments. Those are kind of dry. You know, but I have very skilled people in my office that do it. Yeah, I mean, it's whatever we're at, 8,000, 9,000. I don't know what it is, right? We can get you a quote, right? Not a small amount of money. But if you have the ability to say, all right, you're right. But the reason that we're contemplating that is that we spent X amount of dollars pursuing this bylaw violation. And we spent Y amount of dollars on this repair because our documents are outdated and it makes the association responsible for that repair as opposed to the co-owner. So a document of revision is not strictly just about bylaws. A lot of times what we're doing is we're shifting responsibility from the association to the co-owner. If your documents are that old, I can almost guarantee you that except for probably the contents of the unit, the association in the event that the dishwasher on the second floor leaks and causes damage to the first floor, I bet the association has to make a majority of the repairs to that lower floor unit as opposed to the co-owner. And then those co-owners, we can talk about fighting with the upstairs court, but a lot of a document amendment is shifting those responsibilities and insurance responsibilities as well. Because it's a lot easier for you as a co-owner to get a higher level of cover insurance on an individual unit than it is for your association to get insurance on the entire project. I mean, that's a multi-million-dollar commitment by an insurance company as opposed to your one unit. So, you know, if you're looking at that, I think what you probably need to do if you're talking about how do we convince our community to go for this, look at maybe what you have had to spend money on in the past because of the way that your documents are drafted and say, if this happens again, we're out another $12,000 for a water loss. Because we can't assess those costs back to the responsible co-owner.
And really just outlining, hey, 2 more of these incidents and it pays for the revision. So it just makes sense.
So that's how you think about approaching it. There may be more options for enforcement in your documents than you recognize. Again, we're happy to
Say that it all kind of changed like late 80s, early 90s. We were built in 90s.
The only thing that really, what I mentioned was when you saw in the 80s and 90s, when you saw those litigation hurdles come in.
Okay.
And that's when there was a law firm that was filing the developers frequently of condominiums. And so these developers started writing these litigation hurdles in to make it difficult to sue them. But the effect is that long after the developer is out of the picture, the association is hamstrung in how it can sometimes enforce its own documents, but then also have disputes with contractors, their neighbors. I mean, you're still property owners. You're beyond just kind of enforcing your own documents. You have the possibility of having disputes with third parties And if you can't exercise all of your legal options, you know, you're just not in as strong a position to operate your organization as other communities are.
We have a second out of it. I've had people move their fences,
Yeah.
move their sheds.
Yeah.
I guess usually bring a lawyer in. I show them what's going on. They didn't do it the right way. They didn't submit the paperwork the right way.
Yeah.
Whatever the case may be. And there's people in this room that know our place. And we don't, the only time we involve a lawyer is if they're delinquent.
Great.
Bottom line.
Gary just shows up at
Good.
the door.
Yeah. Yeah. Go.
Anybody's property.
Go.
Does anybody on the board?
Yeah. But go. I mean, it's good to hear that you have had the, hopefully you're talking about, we've gone and done it and they've complied. Right.
Absolutely.
Great. Glad to hear it. You know, you don't want me involved.
We have certain documents that have to be signed, certain information from contractors and everything else.
Yeah.
If they don't comply to those documents, they'll move it. They have to move it.
Yeah.
And
Good.
it's happened.
Yeah. Good. And it's glad to hear a success like that. Unfortunately, and this is why I'm in business, that's not how it
works.
that's not how it always goes. You know, and to the point of, well, we've had these, maybe there's been a violation that's been there that prior boards have let slide, or that you didn't even know about. So though this is again, you catch the one guy with the shed and he says, what about this guy with the shed over here? Yeah, it's been there for 30 years, but it's been behind a row of arborvitae. I didn't know it was there. We're not going in, we're not the condominium police. We're not running drones overhead looking for violations, right? The answer to that is certainly in condominium documents, you can almost always look and see there's what we call non-waiver language. It'll be usually towards the end in the enforcement provisions that says something along the lines of, failure of the association to enforce any of the restrictions herein shall not constitute a waiver to enforce that restriction. So, yeah, but the shed's been there for 30 years. Yeah, but we didn't know about it. It's still a violation. It's got to go. And you know, the case law has upheld what we call these anti-waiver provisions, which is our failure to take any action, or for prior boards to take any action, right? One of my standards is we don't have to make the same mistakes that prior boards did. We're allowed to do it right.
That's how the guys got.
Yeah.
Because the prior board went against the bylaws.
Yeah.
And allowed someone to do it. In fact, it was our lawyer who lived in the same place.
Yeah.
Another person wanted to do it.
Uh-huh.
And we said, no, well, what about them? Well, it was another board and we're going by the bylaws. They didn't.
That's exactly right.
Well, and that's especially important. I hear new boards all the time come into play and they say, well, the precedent has been set because other boards let them get away with it. That doesn't mean you should continue it. The precedent has not been set. You do the right thing as the new board and uphold what you're supposed to.
The level of violations that have to exist for the law to legally recognize a change in your restrictions is pretty high. Right. So if you came to me and said, Ben, our documents prohibit fences. 40% of our lots or units have fences. Well, the nature of your community may have changed such that even though there's that anti-waiver language in there, a court may not be willing to order that is, a court may be willing to say, I'm sorry, but the nature of that community has changed to such an extent that fences are no longer prohibited, you know, and so, but it's the rare case.
When the developer had bylaws made, he didn't include fences or sheds. So we had him pay the fees.
Mm-hmm.
We wrote the addendum. He went down to Wayne County and filed everything and had it all done.
Great.
That's how it's set now. That's how it's been for 28 years.
Yeah.
I think we can take two big takeaways from here. Flamingos and sheds are the real problem.
Yes, they are. Don't leave out holiday skeletons. People, we had to have somebody move it because they wanted to keep it out there year round and put hearts there.
Decorate it for the seasons.
Big tail skeletons. Oh, yeah, sure. You want to see this thing every time you go out in the sun, right?
Well, to Ben's point, I love when this happens, when we have our educational seminars. there are so many layers to them. So when we had CAI in here and we were reviewing like what your goals are as a board, when we had our reserve study experts in here as well, the theme is everything starts with foundation. So if you are actually implementing and creating and refining and recreating your documents, that is going to help you and empower you on every level of your community. So I think it really just starts there. It makes your job a lot easier if those pieces are in place, saves you money as well too. And I know it's easier said than done to then revamp the entire thing, but at some point in time, you know, we're here to guide you as your management company. And if that's a suggestion that's coming from, a recommendation that's coming from us, and it's also coming from our lawyers who do this day in and day out, we can visit those options for you. And also when you were talking about when somebody's moving in the community and wants to refinance, that we actually have, we have been working with people who are moving in with associations and with real estate agents on educating exactly where to find those things when people are moving into communities. As a mortgage company, we specialize in associations as well. And we want to make sure that when somebody does move in, that they do understand that they live in a condo. And it's not uncommon that they don't.
Right.
Right?
Yeah.
They don't understand the
That's correct.
rules. Yeah.
Absolutely right.
And we want to make sure that we're clarifying that not only from the sale points, but also from the loan points. And the fact that we understand all of that is really nice too. So I want to ask of you, if you know anybody, to see anything that comes up for sale in your communities, or, you know, put us in touch with the real estate agent. Let us get in contact with the sellers, because we can help that process for you as an entire association to make sure that the people who are living in your community are actually educated and can fully understand. And to that point, we do have our KS perks too. So there's a free home inspection in there, and if somebody's a real pain, you can just hand it to them and suggest that they get the inspection and move out.
Even on those words.
Lawyer it up a little bit.
You're not, you can't put a fence around your property.
Yeah.
It's in the documents, just like that. The developer in the city actually said that that was what was gonna happen. And we had somebody move into a home. She said she was a paralegal, and that when she's through with us, that she would end up putting a fence around her property at the time. I said, well, she still doesn't like us.
Yes, yeah, yeah, no.
Yeah, sometimes
That was
it's
back
just-
in my time.
Yeah. Sometimes it already goes a long way, I'll say.
She's still currently unaware.
It doesn't matter, I don't care.
I'm
Oh.
a lawyer. Ben, thanks so much.
Absolutely. Thanks for having me.
Your presentation was amazing, your information was great. The way that you present was fantastic.
Well, thank you.
A lot of times when we talk about on the law, it doesn't get very excited. You guys did an excellent job. Thank you, Ben. Thank you.
Certainly.
And yeah, keep in mind, how many questions?
And we'll send out, like usual, the recording of this, the notes, the presentation stuff. And Ben's info is in here too, so you can always contact him.
Absolutely.
You don't put that in the portal?
Yeah, it's on there too. It's on the website and the portal.
No.
Show you.
Well, Hampton Square, so you know us well.
I do, yes. Nice to see you in person. We're gonna get that. We're gonna get that finalized soon. I hope.
Thank you. You have a lot of presents.
Oh, thank you very much. Yeah, well, I'm usually gonna be up in an office. It's nice to get out and talk to you.
Also, you know, it's funny, I was very straight on a few juries.
Uh-huh.
And I know this attorney is presenting in court. The person who speaks more like you